All right, you may be excused. Thank you. Bye-bye.
Thank you, Your Honor. You too.
All right, now we'll turn our attention to RNA Financial versus David Villanueva. Mr. Abrams, you may begin when you are ready.
Okay. The defendant has been occupying the premises since March 1, 2019 until the current date. I have about 6 checks that were returned to me, NSF that he gave me, and that was when he was paying. He's no longer been paying. Presently, there's $14,400 due on the account, and we're seeking possession.
Okay, very good. When I looked through this yesterday, I didn't see the notice to vacate. Do you have that?
Yes.
And then
Okay,
also, this must have been filed this morning. It wasn't in yesterday, but I have a plea to the jurisdiction. So I heard all that you said. Let me put you on pause real quick, bounce over to counsel. Counsel, go ahead and present your motion.
Yes, Your Honor. The attached to the motion was to our answer was Exhibit A, which shows the instrument under which the defendant is in possession of the property, and it's a conditional sale agreement. The occupancy of the property has been since 2011. This is the 3rd time we've been to court with this contract. The first time was with under cause number 28324 in 2019, where Mary Sosa was the plaintiff. She was the successor in interest to that contract. Court rightfully acknowledged that there wasn't jurisdiction there and awarded us attorney fees of $1,000. The second time was June 22nd, 2020, under cause number 29620 with this plaintiff and this defendant. And again, this court recognized the lack of jurisdiction. It's a contract for sale. And under the government code 27.031 sub B sub 5, this court is not the proper venue for addressing this particular issue between the parties.
Very good. Mr. Abrams, let me get a response. What's going on here?
2 things, Your Honor. Number 1, we notified them of a default on the mortgage if they think that that's what it is. And we had a sale of the property back last year. The contract that they allude to is a conditional sales contract that talks about goods purchased, does not talk about real estate. It talks about a UCC filing, which is a personal property filing. If they think it's a purchase of real estate, they have the wrong contract. And needless to say, we were not privy to it. We bought the property from Lucy Sosa and Jaime Sosa a couple of years ago. So we don't feel, based on a conditional sales agreement, that it is a sale of real estate. I don't see any place in here that talks about real estate. I see goods, retained title goods. I see we can come in there and take possession of goods. I see that we can file a financing statement or a UCC. All those are personal property, nothing to do with real estate property.
Counsel, do you have a response?
Yes. As far as the contract, it's clearly a contract for sale of the property in question. The case law, as well as Texas law, is pretty clear, regardless of how you title it. As long as it's the sale of the property that's intended, that's what is affected. And that's exactly what's going on here. It's pretty unambiguous, actually. It's $68,000, 20 years financed at $600 a month. Payment starting June 1st of 2011. In 2031, the property would be released of the lien. This is an action to enforce a lien that's showing up here in this court today. Regarding any other sale, I'm looking at Tarrant County records. I don't see a sale.
Okay. I have a question for Mr. Abrams. Mr. Abrams, you say that there's nothing about real property, just goods, but here on the conditional sale agreement that was provided by counsel, it says the following goods and it lists an address as being the goods.
Yeah, but that.
How is the court, well, hang on, how is the court supposed to interpret that?
You can interpret it any way you want, but it doesn't talk about real estate. It talks about goods at 5524 Humbert is the way I would interpret it. If they said the following real estate at, then it would be totally different, but goods is personal property.
And then if you look at the bottom paragraph where it says seller, how's the court supposed to interpret that?
Seller shall retain title of goods. Is that what you're talking about?
Yeah.
Again, it says seller shall retain title to goods. Goods is not real estate. Goods is personal property. I have no idea what the contents of that house were. I don't know.
And then when you look at the last paragraph where it says commercial code, mineral rights, it's not included with typically with any sale of real estate. That's always a clause that's included, whether those are assigned or not. How's the court supposed to interpret that?
That's the only thing in here that would indicate that it maybe is real estate, the mineral rights. But when you look up at the first part, it says purchaser agrees to execute financing statements. That's a UCC, that's personal property. Purchaser shall keep goods. That's personal property. Full balance becomes due on default. The only potential item of real estate in this entire contract would be mineral rights. There's no legal description. There's no nothing in a typical real estate contract.
Okay, well, this is what I'm going to do. I'm going to take this case under advisement. I'm going to set it up for another special hearing where we just deal with this exclusively. And at the time of the next trial, I'd like to see some documentation of what has happened with this property prior to the Sosas and I mean prior to Daniel Villanueva or the Sosas and what we have in place here, because I don't think I have a full picture of what's going on. Any questions from either side?
Yes, Your Honor. I would just raise the issue that I would imagine that the plaintiff would be collaterally estopped from raising the issue, contesting the nature of the contract, as we've already done this before, and there was no appeal.
Go ahead.
If I remember correctly, you did not hear it last time, Judge. Judge Valdez heard it, and he didn't say anything other than he ruled in favor of defendant. He didn't say why or anything else. He just ruled in favor of defendant. So as it relates to collateral estoppel, I think it's a little far reaching.
Well, I do think Mr. Abrams brings a legitimate point with raising the issue with UCC as respect to some financial transactions. But again, I want to make sure that I devote the applicable time that is necessary for this particular case. So we'll reset this and you will hear from our clerk, Lisette Arizmendi, on a new date. And again, want everyone to bring any and all documentation that you have related to this property and related to your respective clients. Any questions from either side?
Do you want us to send you my NSF checks and everything else that have been presented?
Yeah, if you want to present that to the court, that's fine. Just make sure that we get a copy over to counsel.
Okay.
All right. Very good. Thank you. Parties may be excused.
Thank you, Judge.
Mm-hmm.